The views and opinions expressed in this episode are those of the hosts and guests and are intended for discussion and informational purposes only. Nothing in this episode should be considered legal advice. Our discussion is based on publicly available information and the professional opinions of our guests. We encourage listeners to review official court records and reputable sources for additional context. Certified Nonsense does not seek to influence ongoing legal matters or misrepresent any individual involved. Our goal is to promote respectful conversation and a better understanding of the legal process. We want to thank you for tuning in to Certified Nonsense. We hope you enjoy the show.
What's going on, everybody? Welcome back to the Certified Nonsense Podcast. I'm your host, Ant Brown, the Bearded Cowboy, and I'm also checking in for Charlie T and Boogie, who are working behind the scenes for this episode. And today we're doing something a little different. This episode isn't about picking sides, it isn't about social media hot takes, and it definitely isn't about spreading rumors. Today we're talking about one of the most talked about criminal cases in the country, the Karmelo Anthony case. And we're sitting down with legal experts to help us separate facts from opinions. The case has sparked debates about self-defense, the criminal justice system, race, media coverage, and how public opinion can shape the conversation long before a verdict is reached. Recently, a jury found Karmelo Anthony guilty of murder and sentenced him to 35 years in prison. But the legal discussion surrounding the case continues, including questions about the trial, the evidence, and the appeals process. Our goal today is simple: to learn. We're asking the questions a lot of people have been asking. What does the law actually say? How does a jury evaluate a self-defense claim? What happens after a conviction? And how does lawyers look at a case like this through the lens of the law instead of emotion? Whether you agree with the verdict, disagree with it, or you're still trying to understand what happened, we hope today's conversation gives you more insight than any other comment section ever could. So grab your headphones, buckle up, and let me introduce today's guest. I got to my right, one of the baddest lawyers on this side of the Mississippi. You know what? Let them introduce themselves. Go ahead, man.
How y'all doing? For everybody that doesn't know, I'm attorney Andrew Wilkerson. My Instagram handle is attorney_Andrew_Wilkerson. I'm elated to be here today. One half of the Not Guilty Boys. Also follow and subscribe on Instagram and YouTube, Not Guilty Boys page. I got my highly esteemed colleague right here with me.
Go ahead and introduce yourself, big dog.
Man, how you doing, brother? Glad to be here. Attorney Michael Campbell, 16-year practicing criminal defense lawyer here in the Dallas-Fort Worth Metroplex. Happy to be here. One half of the Not Guilty Boys. We're currently 17-1 in murder and capital murder cases all over Texas.
Wait a minute. Whoa. 17-1?
17-1,
baby.
But these boys are the Patriots.
That's whether it's a no bill, whether that's getting it dismissed at pretrial, or going all the way and going to trial and beating it at trial.
17-1
in capital murder and murder cases.
Listen, I'm gonna go kill somebody and have them give me. No, I bet not. I bet not do that.
I actually heard that a few times before, man. I actually heard that a few times.
Well, I got a couple questions I want to ask y'all, man. I mean, y'all got time to kick it with your boy today, don't you?
Hey, man, let's shoot.
Hey, man. Well, let's get into it, man. We got a couple questions. We're gonna get their opinion. We're gonna try to clear up some of these mishaps, these misunderstandings. And listen, we're gonna have a good time. We're gonna laugh a little bit too, but most of all, we're gonna learn today.
Let's do it.
All right, so I want to get the conversation started today. Either one of y'all jump in whenever you get ready, man. What legal standard must be proven for self-defense to be an actual claim?
Self-defense comes out of the Penal Code, Section 9.31, Section 9.32. 9.32 specifically deals with the right to defend yourself in using deadly force. What has to be proven is that, and specifically speaking to the Karmelo Anthony case, is that in that situation, Karmelo Anthony had to have reasonable fear of imminent danger of threat of serious bodily injury that's going to be that he's going to be harmed, and based on his mental mindset at that particular time, the mens rea, that gives him the ability, justified ability to act and defend himself. So again, I said that very technical, but let me say it in the layman's term. If you come up on me, and I think you finna harm me, whether you finna punch me, jump me, stab me, shoot me, whatever I think you finna do to me, and I think it may cause me serious bodily injury or death, in my mind, then I have the right to defend myself per the Texas standard. There is no duty to retreat. There is no stand, and we have the right to stand our ground in Texas.
So, with standing your ground here in Texas, if you walk up on me and I perceive that you are going to harm me in any type of way that I'm in fear for my life, I have the right to use whatever level of force that I see necessary to avoid this confrontation or to keep myself from being harmed.
So it's subjective and objective.
Okay.
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 So subjectively, yes. If there's apparent danger, it doesn't have to be a real danger.
Okay.
All a person has to prove is that there was some imminent fear in my mind because I thought this person was going to commit some kind of harm to me.
Okay.
So, sometimes people may be reaching, look like they reaching for a weapon,
Okay.
but they actually reaching for a gun. So the Trayvon Martin situation, that's what George Zimmerman used in saying that I thought he was reaching for a gun when he reached for his Skittles or whatever.
Whatever it was.
You're
Right.
And that's, even though we all hate it, that's what justified Mr. Zimmerman's action, because that apparent danger is enough, it's equivalent to real danger.
Gotcha. Okay.
So whether a person have a gun or not, if it's reasonable for you to think they do in the way that they're acting, their demeanor, they're saying something threatening to you, they're coming at you, then you legally have a right to defend yourself.
What Attorney Wilkerson, I'm gonna piggyback on that. He says that in the event you appear to be in the act of conflict of some sort of threat towards me, I can defend myself however I see fit. Does that still pertain? Does it stay the same when it comes to law enforcement, or is that different?
Okay. Well, there's an extra element to it when it's law enforcement.
Okay.
Their apprehension of you or their arrest of you has to be unlawful. What they're doing to you has to be unlawful. So you can't just do it. It ain't just a blanket. You see what I'm saying?
Okay.
If a cop, if you walking down, I don't know, Good Latimer right now, and a cop just pulls up, hop out the car, and throws your face in the ground, start putting the cuffs on you, without announcing what they're arresting you for.
Right.
Maybe something like that. But you can't just defend yourself from the police because you don't want the police to. You know what I'm saying?
You can't defend yourself because you don't want to go to jail.
Right. If it's part of a lawful arrest, then you probably don't want to do that.
You don't want to do that.
Gonna get booked and see that you got an assault of a public servant when you get in there.
Gotcha.
So,
but in any event, I can still call you.
If you don't know what to do.
Okay, cool. Okay, so let me ask you this. Were you surprised with the verdict and the sentencing?
I wasn't surprised after I saw the defense or lack thereof that was put up. Once I saw, I don't know if Mike Howard just punted this thing mid-trial, or I don't know what the defense strategy was going into the trial. But once I saw, first of all, how Mike Howard allowed a judge to just rush this case along, we gonna pause right there. Judge, we're not coming in on a Saturday. Whatever it may be, my morals, my religious, my family issues is not going to allow me to be here on a Saturday. And there's a reason for that. We're not coming on the Saturday because I don't want you to drag this jury down here on the Saturday.
Right.
Because at that point, the case is in my court. And now the jury is rolling their eyes at me because now the case is in my court and I'm asking the questions and they feel like I'm holding them hostage on the Saturday.
Gotcha.
It's all about the optics. So, also not calling Karmelo to the stand in a self-defense case where his mens rea, his mindset plays a part. I question that. Not put up any mitigating evidence once they got to the punishment phase.
Okay.
All of these things, once I saw these things unravel, I knew we were coming back with a guilty in the guilty and punishment side, and then, excuse me, the guilty innocent side. And I also knew that the punishment was going to be heavy when he only called Karmelo's mom in the punishment phase to testify and nobody else.
So do you feel that the self-defense claim was thrown out because he was never allowed to speak his piece on what actually happened?
Well, I wasn't there.
Okay.
Neither of us were there.
Okay.
But and I wanted to be. We just had a docket of our own. But I think that the way they presented it was inefficient
Okay.
and ineffective.
Okay.
And this is just from what I'm hearing. And to piggyback on that question you asked, I wasn't surprised by the verdict, not because that's what I wanted to happen, because I wanted that boy to go home. But I wasn't surprised because of everything that kept coming out. People asking why the attorney going so easy on the witnesses. People asking this, people asking that, and it kind of just. Plus, I know that that's an away game for any black man. I don't care if you live in Collin County. That's an away game. You got all white jury. You see what I'm saying? You know, they were. You need somebody that's gonna stand tall and get the job done and not falter or conform at all in that type of environment.
So could the case, because I know, for example, like let's say hypothetically, if this situation would have happened in, let's say, DeSoto, Cedar Hill, Duncanville, something of that nature, Dallas County, that case would have been pushed to Dallas County. Did this, and I'm assuming that this happened in a Collin County city, which is why it went to county court. Do you feel that played you said it was an away game. How could the attorney have made this a home game, or do you just show up to play at the away game?
Well, it's a couple of plays you run, my boy. Like, first of all, you're right. If this would have happened in DeSoto, Cedar Hill, then when we go to that trial and we pick a jury, majority of that jury, over 50%, is going to be African American. Gotcha. I tell my people all the time, and I'll tell them the public here today, you got to know where you at if you committing crimes. You got to know what jurisdiction you're in. When you're out in the Collin County, Denton County, Rockwall County, Johnson County, Ellis County, you got to be careful in them parts. Right. Because majority of the jury makeup, if you need to fight that case, is not going to look like you. Gotcha. Okay, so when there's only 10% of that community is African American, that's the amount of people, if they show up, that's going to be in that jury pool to choose from. Mm-hmm. So that's why my counterpart say you fight an away game. Right. But what the attorney could have did, to answer your question, he could have filed a motion to transfer venue, motion to change venue. But the caveat, because I know a lot of people have been asking about the motion to change venue. Here's the caveat to that. As the defense attorney, I don't get to select the county that it goes to. It goes to any contiguous county that touches Collin County. So that judge could have sent it to Rockwall. He ain't got to send it to Dallas. He could have sent it to Grayson County. He could have sent it to Denton County. And would that be any better? So a motion to transfer venue is kind of risky when you look at the surrounding counties and of course we would have wanted to be in Dallas County. Right. But the judge probably knew that would be a defense-oriented county, and he wouldn't have sent it to Dallas County. So he would have sent it to Rockwall County.
So, and we just put the flag here. I filed a motion because I want to change the venue because I don't like the optics of what I see. Right. The judge makes the decision as to where it goes. Right. So he makes that decision. Right. Got you. Okay. Right. So it's not
and it's based on we don't believe we're going to get a fair trial in this county. And go ahead, Drew.
Mind you gotta have you gotta have a requisite reason in order to do it. You can't just do it.
You can't just do it because you can.
So I'm saying all that to say is, to me, them people down there was very careful about what they was doing leading up to trial. You know what I mean? You heard about the fiasco about the race thing versus the father running his mouth versus the mom versus if he knew the judge. All that was collateral stuff. Gotcha. But as far as the judge, he didn't really do too much. But you didn't hear too much about him until you heard he wasn't letting no black media in, and until you heard that. That's the first thing you heard about the judge. And going back to Dallas County, man, I just gotta take this time to say this anytime I can, man. You know, I am you know, anytime you go outside the county, me and Mike, you know, we are people that people don't expect to be attorneys. They say that a lot. I wouldn't expect you to be an attorney. Because when we walk, talk, whatever, right? Well, them white folks look at us the same way. So anytime I got the chance to say this, I say this. I'd be proud to walk in Dallas County, man. Man, we got how many black female judges we got, bro? It's beautiful to me, bro. Like it's like I'm proud of it. You know what I'm saying? We got what? I mean, bro, it got to be at least 6, 7, maybe 8 black judges. Women. Ernest White. He's a black male judge, but he's gonna be gone in January. But he's getting replaced by a female black judge. You see what I'm saying? So what I'm saying is, it ain't about black or white for me. You know what I'm saying? It's about being in an atmosphere where you can succeed. You see what I'm saying? And when you walk in Dallas County, that ain't nothing we really worry about as far as a race thing. That ain't really nothing we gonna worry about with the judge or with the jury. Now, we might worry about somebody not really liking how we do business because how aggressive we are, and we got to deal with that. But you know, anything else, man, you know, I'd be proud to walk in Dallas County, man.
So when it comes to the sentencing of this whole case, it's a 2-part question. How is a 35-year sentence determined in a murder case? And then part B, what factors may have influenced that particular, not so much the verdict, but that particular sentencing?
Well, you know, murder carries 5 to 99.
Okay.
If you get found guilty of murder, even if you have no criminal record, you're not eligible for probation from a jury on a murder case. Okay, at all. Okay. Now, we talked about this a lot during the trial and shortly after. There was a manslaughter, lesser included offense that the jury could consider in deliberation. But part of the reason you say, what's the factors in this sentence? Well, the jury wouldn't have needed to hear from Karmelo to understand, number one, let's start with self-defense. Again, what was going through my mind at the time I acted? Was it reasonable for me to defend myself? What I knew about the Metcalf twins, you know, my epilepsy, my shoulder injury, you know, everything that was playing in my mind at the time I acted, why I felt I needed to defend myself. So that's one reason you put them on the stand. The second reason is just for whatever reason, the jury is not buying the self-defense claim. You put them on there to pivot to manslaughter. Gotcha. Okay. Any competent defense attorney knows that, hey, if that jury is not buying our not guilty because of self-defense, our legal justification, you pivot to the next best thing, which is manslaughter. Manslaughter, if we get found guilty of that, he can still get probation. So that 35 years, I think, came from, I know his trial lawyers brought it up. You could, let me say this too. Even if you get found guilty of murder, you can still get a manslaughter punishment on the punishment phase if you put up that type of case on the punishment phase. So you got to be ready for both sides. You got to be ready for guilt and innocence, and you got to be ready for punishment. Most attorneys confident think they won't never get to punishment. But even if you do, you better be ready, okay? Because you still have an opportunity to get this down to something reasonable. What I've read in what I saw, his trial attorney, he didn't put up much of a punishment case. So that 35 years could have easily been dropped to 2 to 20 if you would have just said, hey, look, this all happened so fast. He didn't mean to do it, okay? And it just happened so fast, he's sorry for it, but this isn't anything he intended to do, and he didn't have a time to think or cool off. Okay, and that's how you get sudden passion on the punishment side, and that 5 to 99 is now chopped down to 2 to 20, something we can live with. Okay, so that's, I think, him not testifying is the biggest factor in the sentence and the verdict here.
So then it's safe to say that this particular sentence could have been significantly lighter and or significantly heavier based on, like you said, the perception that the that the defense put up with this case. So, you know what? Hey, it's certified nonsense. I'm just gonna ask you. You don't have to answer. I'm just gonna ask you. Do you feel like the defense dropped the ball? I've heard it. A lot of people said, you know, he didn't do this, he didn't do that. He could have, woulda, shoulda.
I must say this before I pass it to Drew because I want Drew to tackle this.
Put your shoulder pads on.
Humanizing your client.
Okay.
Putting a persona on them.
Okay.
The importance of that in being a defense lawyer. You don't want the state to just keep saying he's a murderer, he intended to do it, he's a bad person, he's the worst person in the world. You put them on the stand to humanize him. He's a 17-year-old kid. What you think, Drew?
Yeah, I do. In some form or fashion. I mean, it's just too much that wasn't done. You know, I mean, you only got to drop the ball once to drop the ball. You know what I'm saying? So if we talking about if they dropped the ball, period, yeah. I mean, even though I wasn't there, I can pretty much tell you the fact that he didn't get on the stand in punishment, and the fact that, and we're not being redundant here. Like, this is really a big deal. You know what I mean? Like, him testifying not only goes towards their self-defense claim, right? Or towards their manslaughter claim. But it also helps the jury understand his thought process and what he was thinking and who he is as a person and what type of time they want to give him. You see what I'm saying? Like, you really let these people, and when I say white folks, people think, dang, he don't like white folks, but I'm just speaking generally. Like, you let these people, let's say this, they have no cultural connection to him. That don't understand his way of life, that don't understand how he thinks, that don't understand, you know, the conversation his mom probably has with him about the police. You know what I'm saying? These are people, you got to groom these people and spoon feed these people in order to get them to come along with your way of thinking. You see what I'm saying? Like, I mean, got the college teacher up there telling him he got good grades, all A's and B's. Got a principal up there to say she didn't even know his name. He ain't never been in the principal. I mean, do something. Do something to make these people that have no cultural connection to him look at him like a human being and say, you know what? This isn't who he is. This was an isolated event. Matter of fact, just so people know, and I don't think people think enough about this, but anytime somebody claims self-defense or any situation like that, it don't take 5 seconds. It don't take a minute. This is a split decision this young man made. Like, this ain't no, he got to think about it, he got to pray on it, he got to ask his mom about it. No, he you know, apparently, you know, in a perfect world, he felt like he was about to be jumped or whatever. And he did what he did. But that's like that. So that's also something you get the jury to realize and speak to him. I mean, how quickly did you make that decision? You see, how did you feel when you made it? Did you feel like it was right when you made it? Do you feel like it's right now? You know, would you wish this on anybody to have to make the exact same decision that you did? Why not?
And that paints the humanistic side of what I'm facing.
Right.
Because I mean, you know, it's crazy you said that, because I think about it like you drive in a car and somebody hits their brake. You have a split decision. You can swerve left, swerve right, and you're not thinking somebody's to my left or somebody's to my right. I just don't want to run into the back of them. And then you go left and you hit somebody, you hurt somebody. It's that quick.
It's another bad decision that had to be made in a milliseconds time. You know.
So how does that play in the case? How does that, like, if I'm the judge. Well, pause before I ask that. Could the judge can the judge, because you said the defense never put him on a stand, so nobody knows his side of the story. There's a lot of, I've seen videos where I think one video he was like, you don't have to look for him. I'm the one that I did this or whatever. And I don't think, and I was telling somebody, I don't think that he was necessarily saying I did this, I think he was taking ownership, accountability at that moment.
That's the point, though. That's you got to let him explain it.
Right.
You see how you sitting right here, just organically, humanistically, trying to figure that out. What do you mean by that?
'Cause why are you-
If
why
you
are
put
you
him on the
doing
stand,
You understand that.
none of the jurors or the alternates got to figure it out.
They know, only thing they see is this boy is dead. You said you did it. You're guilty because you never got the chance to say why you said what you said or what was going through your mind.
But hold on though. That's the beauty of the law. Okay. Because the law says the first step in self-defense is that you got to claim you did it. You can't say I didn't do the act and claim self-defense. It is you claim the act and then you say I did the act out of self-defense. So his words to me didn't hurt him. I know that's why you don't let people interpret your words. You don't let people, I don't let people put words in my mouth. Okay. I know exactly what I mean when they come out of my mouth. Right. Only Karmelo would have known what he meant when he said, hey, I told him not to put his hands on me. Right. Hey, no, it ain't alleged. I did it. Right. To me, quite simple, quite frankly, he meant I did it, but I did it out of, if you just look at the totality of all his statements together. Right. I told them not to put their hands on me. They still did that. They grabbed my backpack. Hey, I did it, but I did it out of self-defense. Right. That's what he meant. And that's why you put him on the stand to clarify that. You don't leave that for interpretation and let the jury do whatever they want with that in the deliberation room. You make it plain and simple, like the Bible say. Make it plain for them. Write it down, make it plain. Yeah, you want to spoon feed it to them like they some babies. Right. You want to give it to them very plain. He meant that he was acting in self-defense. Yeah, I did it, but I told them not to do what they did, and they still did it. And you know what? I heard a juror say this one time. I'll never forget it. You know, he said, "I'm a license to carry, and I know how far I'm willing to go if anybody come towards me. I know how far I'm willing to take it. Right. If you step towards me, I know how far I'm willing to take it." And that was a white man. So, you know, Texas is a gun-toting Second Amendment state. Right. So him having, people say, well, why did he have a knife at a track meet? I'm pretty sure it was plenty of kids up there with pocket knives at the track meet. That don't hurt me. That don't scare me if I'm going to trial and he had a pocket knife. Right. Okay? The fact of the matter is did he need to defend himself when the Metcalf twins and their friends approached him? Did he think he was physically capable of fighting them? Because people say, well, he should have just fought him. Well, had he fought him, we'll still be here. That ain't the legal standard. It's not force versus force. So they was only trying to fight, so you should have just fought him. The standard is whether I thought you was capable of committing serious bodily injury or death to me, whether you fighting me, kicking me, stomping me, whatever you're doing, then I can use deadly force to defend myself.
So is it safe to say you can't, the saying is for every action, there's an equal and opposite reaction. I can't punch you and tell you how to respond to me punching you.
Exactly.
I can't punch Andrew and say, I punched you. You only can punch me.
Well, now it has to be reasonable.
Right.
Okay. It has to be the force, the fear has to be reasonable, and the force has to be reasonable. So now, usually those match up. Okay. Usually if somebody believes you when you say, I thought they was gonna kill me, then they cool with you using deadly force, right? You see what I'm saying? Now, it can't be, I thought you was gonna punch me and I shot you.
Well, no, I don't mean you thought I'm saying we sitting here, I haul off and I hit you. I hit you. Is it still self-defense if I hit you? Because if I hit you out of nowhere, you don't know how far I'm willing to take me punching you. You don't know what's going to happen. So if you stab me, shoot me, whatever the case may be, is that justified based on what I did to you?
As long as the jury believes that your fear was reasonable. Drew's fear of you punching him, if he punched me again, this could lead me to brain damage, or he may try to stump my head into the ground the next time. And if he does that, then I may not be here. I may be brain dead. So at that point, if he can articulate it to that jury when time comes, then he may be justified in using deadly force.
I would focus, if we're talking specifically about this case, I would have focused on the fact that he was outnumbered. That's what I would have focused on. Okay. I wouldn't have put a whole lot of emphasis on exactly what fighting technique he was going to use. Right. I would have put a whole lot of emphasis on, once I'm outnumbered, that heightens my percentage of this going real bad for me. Right. And me, receiving serious bodily injury or death. Boys got track spikes on. Hey, listen. People ain't thinking I'd have made all them arguments. What happens to a guy if he get kicked with a track spike? You see what I'm saying? He didn't know what the Metcalf boys was gonna do.
And all you need is an expert to justify it. A medical expert to say, yeah, I'd heard doctors say one blow can kill. So if he can jump out multiple people, that could be deadly. Right. So all you need is that medical expert testimony. You need a medical expert to his epilepsy.
How does that play? Since you brought that, how does that affect this particular claim? Because that's a medical diagnosis.
Yeah, exactly. And he is currently taking meds right now in TDC for epilepsy. So if that was diagnosed medically, that's on paper somewhere. Right. That can easily be proven. All I need is just to subpoena his doctor that diagnosed him. He gonna want his fee. I'm gonna pay his fee because it's gonna be worth it to my client. Right. But I'm gonna get him to court and I'm gonna put him on the stand and I'm gonna have him testify that if my client would have received multiple blows to the head or been kicked to the head multiple times with his condition and having epilepsy, how that would have affected him, and that would have been different from somebody who did not have epilepsy. So when it comes to reasonableness, you got to remind people that, hey, it's reasonableness based on, this person's situation through his eyes, okay? But if you didn't have epilepsy, then you might not have had that similar fear that Karmelo and Anthony may have had when the boys approached him.
Hey man, that's something to think about. Like your because that change, like you said, that changes your state of mind. Because what happens if you hit me and I have an epileptic seizure, or I have some type of episode? The punch may not have killed me, but it could have triggered this that does kill me.
And let me tell you what's undeniable. You take a victim as you get them. So if a Metcalf boy would have punched him and he would have had a epileptic episode that ended in death or something, that's murder. Like Metcalf don't get to say I didn't know he had epilepsy.
Right, because they go right.
He don't get to say that. You take them as they come. So so understand, if you have a medical expert to testify that were true, that heightens your reasonableness. Like, bro, I mean, I done been in a fight before, fam. I might be cool today to let you get the first punch today. But if I got epilepsy and I think that I possibly could have an episode that, nah, bro, I'm not letting you hit me. No matter how good I fight. Like, I'm not finna let you get down on me like that.
Listen, I ain't gonna let you get down on me. I did. Yeah. I'm too fat to be trying to fight because, listen, I get tired fast. We get to fight and I get to breathe it hard, and I done lost the fight because we ain't even talking about death now. We talking about this big old man then got beat up because he can't breathe. I think so. Take me in the court. I know you said you wasn't there, but take me in the courtroom. You're the defense attorney. At what point do you? Where do you object?
I'm not letting nobody answer if it was self-defense or not. Okay.
They're not legally qualified to answer that question.
I'm narrowing my cross-examination to statements that were already made and lies that I know you told on direct just now. I'm calling the Metcalf boy. I'm playing both his interviews. I'm getting them in the evidence. I'm crossing them on them interviews.
Now, what you said, the interviews. So I'm assuming there's more than one interview with the same boy. Yes. And so with it being two different interviews, because I don't know, so I'm asking, are the interviews contradictory?
Yeah, they are. So there was an interview the day of, right after it happened. Okay. right outside the his home with his mom. Then there's an interview later that day inside with Fox News, and the stories are kind of different. And we're waiting on these transcripts of this trial to come out. But from what I'm hearing from people who was inside the courtroom is that the witnesses' statements were different from Hunter's statements the day of. Okay. So that's why you say where the ball was dropped. You as a defense attorney, you got to subpoena Hunter. Hunter is an eyewitness. He was allegedly there with right there with Austin when this happened. He's one of the main star witnesses. Why wouldn't the state call the twin? You got to really ask yourself that.
So not only did Karmelo not get to defend himself, but I think Hunter didn't get to express his perspective on what happened.
And I know why.
Okay.
I know why. The defense had subpoenaed Frisco ISD, and they had Hunter's disciplinary records. Hunter was a hothead. And this ain't nothing I made up. His mama just admitted this last night on TikTok that he threatened some cheerleaders at right. Wow. Not cheerleaders from the opposing team, but the cheerleaders that's there. Go Hunter, go Hunter. The girls casually talking. They had lost to a team that ain't won in 3 years. Okay. So you know how cheerleaders do. They capping.
Right.
Hunter got mad. Can't take it. Threatened one of the cheerleaders. Call up Fat B. Told him, hey, my hand's bisexual. They go both ways.
You know, I done told somebody that before. I done told somebody that before. Listen, these hands ready to eat for everybody.
Well, when Hunter said that these cheerleaders, you know, these are white cheerleaders. Okay. So they was really scared. So they went and told Hunter's coaches. They went and told Frisco ISD administration. You think something happened to Hunter? The coach told them, y'all ain't gonna tell the police. This didn't happen on campus. Canes ain't on campus, so y'all gotta go talk to the police. Frisco ISD investigated, nothing came out of it. Hunter's still on the team. Austin and Hunter were known. I got referees who rough games out in Frisco ISD and say them boys on the field was hell. Just you know, terrorists on the field. You know, so it caused all kind of problems. So, you know, not to call Hunter, the state didn't call him because they didn't want none of his character to come out.
Could the defense have called him?
Yes.
That is a drop of the ball.
Yes. But see,
Go ahead.
Well, damn it, I'm getting upset here.
Especially when you know, first of all, you got to know, okay, Hunter said this. Now, these 21 witnesses are saying this different from what Hunter said. Now, if we put Hunter back on the stand to see if what Hunter said was true or these 21 witnesses said was true. Now, if Hunter get up there and said, I'm telling the truth, that means all 21 witnesses are lying. And who would tell 21 witnesses to lie? Besides the prosecutor and the state of Texas.
Whoa, wait a minute.
Hey man, when you trying the case, you can't hold no cards back. It's no other way 21 witnesses would tell the same lie unless they hadn't been told to tell that lie by the state of Texas.
21 people said it was green. Hunter said it was blue.
You get where I'm going?
And nobody wanted to know why he's saying blue and they're saying green.
I think he should have been subpoenaed. If the state didn't call him, guess what we doing as the defense attorney? We call him. You know, we like to call Hunter Metcalf to the stand.
See, that's what I was gonna say. Like, people sometimes get annoyed with our methods. Yeah. Let me explain that. See, the state plays games. Okay. The state will give you a witness list with like 200 people on it, or they'll give you a witness list with 65 people on it, and they only plan on calling 3. You see what I'm saying? What we do is we go through that witness list with a fine-tooth comb, and we figure out all the players. We put a dash me right what everybody did in the case, right? Usually what I do, this happened to me one time as a freshman attorney. I saw a witness's name. It was a DWI case, so it wasn't a whole bunch of stakes, so it's okay. But I saw a guy's name on the state's witness list, so I ain't call him. Well, we got to try, and they ain't call him. That's the game they play. So what I'm telling you is ever since then, for 12 years, when I go to trial, I subpoena everybody on the list. 200 people. I want everybody. Ooh, they be mad. Well, all I did was put the yellow tape around the crime scene, man. Do I really need to come on down here, man? We'll let you know if we're gonna let you go when you get down here. You see what I'm saying? Just so my point is that could have happened. Like, there's no way that the DA is not going to call the Metcalf brother. Right. We'll just cross him when they call him. And then, DA, they got disciplinary, Nah, tell him to chill. We ain't going to call him. Yeah, we ain't going to. Yeah, this trial's going pretty well. We're on our 21st witness, and they've only objected 10 times. I don't know what he was thinking, but, at some point, and he can do that. He can decide at any point in time not to call a witness. And that's why we have to subpoena them ourselves. And look, when the state subpoenas them, we can rely on their subpoena. It's case law for that, right? But that tells me that the state ain't subpoena them and the defense attorney ain't subpoena them. And another reason why I think that they didn't subpoena them, because Mike, correct me if I'm wrong, but the judge apparently gave them an extra 2 hours to go find the Metcalf boy, right? Well, if you subpoena somebody, you get to say, Judge, I got the subpoena right here. It was returned. He signed it. It was served. I'd like a writ of attachment. Can you send one of your constables to go get him? You see what I'm saying? That's how they work if you actually did what you were supposed to do. But if you don't, Judge was just, throwing him a ball. He was throwing him a bone. That good old boy stuff. A judge would have told us, Mr. Wilkerson, you didn't subpoena him. Well, tell us why you didn't subpoena him. Tell us why. That's very irresponsible of you, Mr. Wilkerson. We're moving on. That's what they would have told me.
But they didn't have to do that because we're playing an away game.
Come on, man. You got to have your T's crossed and your I's dotted, bro.
So, with this being said, and again, this is so prolific because a lot of people, what you guys are shedding light on, a lot of people don't know. We only know what we see in the media. We don't know that. We don't know the ins and the outs. So you tell me he's subpoenaed. You say they don't subpoena him because when you look, he doesn't look good on paper. On paper, this could be a home run ball for the defense. Now, I gotta ask, how does this help in his appeal?
Well, it's all still relevant information.
Okay.
And you know what? I'm not gonna say stop talking, Metcalf. Please keep talking. Please keep talking. Because, you're just confirming what we already know. That the Metcalf twins was bullied. Guess what? When we try cases, we got a formula. I open, Drew close. He's a master closer, but I give the opening statements. Okay. In my opening statements in the Karmelo Anthony case, I will and would have called the Metcalf twins bullies.
No. Pause, because you're not gonna get off like that.
Hold on, we starting the case. You setting the tone early.
You're not gonna get off like that. You gonna have to. I'm the judge. You gonna have to give me your opening argument. I need to hear it.
Judge, this all boils down to who was the aggressor. Okay, if the Metcalf twins are known to be aggressive, the jury needs to hear from that because they could be acting in conformity to the character that people already know about them. And if they known bullies, we are saying that they were being bullies on that day when they approached Karmelo Anthony. And they were being the first aggressors. And that my client had the right to defend himself. And like I told someone earlier, Frisco ain't big. Frisco, and these kids on TikTok, these kids on all the social media. So who's to say he didn't know about the Metcalf twins? Who's to say he didn't know how they coming? And that was also playing a part of this. So, look, I'm establishing that early with the jury. That's what opening statements is for me to establish the report. And if it's on me to prove that he was a bully, when I go out there and say that, it's on me. Or then I lose my credibility with that jury if I can't prove it. But when I know I got these cheerleaders subpoenaed, and I got the records for Frisco in my file, we going into that.
Do you whatever you have in your file? Do you have to give that to the prosecutor?
Not as the defense. It's vice versa.
Okay.
The prosecutor has to give us everything, even if it's damage to their case and beneficial to ours. They have to turn it over.
So if Austin Metcalf got upset at Brahms and knocked over 3 ice cream cones and they have that in their file, they have to give that to you. You need to know that he done knocked over vanilla ice cream because somebody liked vanilla and he done knocked it over, and you need to know about it. Man, listen, I don't know about y'all. Listen, I'm learning. I told y'all earlier, you gonna learn something today. So you telling me that, and that brings me to my next question. You said that these boys are on social media. Social media is rampant everywhere. Everywhere. You can't listen. You can't fall in the middle of the street without being on World Star, Instagram, something. How do you think, or do you think, social media affected this case in any way? Could it have bettered the case, or could it have damned the case?
I think it damn the case, honestly.
Okay.
It ain't nobody's fault. It's just, you know how rumors got around in high school. Rumors get around on the internet.
Okay.
Folk taking sides. I think that it took away from what the focus was, and the focus was to come with an airtight, sealed defense for this man, for this boy. I think all the going back and forth. I don't think that any party to the case should be involved in the media unless it's totally strategic. Because people develop their own opinion, and then that's what's so bonkers about the fact that he never got the opportunity to speak, is because you had all this stuff out here. You had this, that, and other, that people was hearing, they was seeing online. People really dry making a lot of this stuff up.
Right.
You know what I'm saying? But, people take with them what they see online. And then for him not to get up there and, his attorney give him the opportunity to set the record straight. Public opinion, I'm a big believer that public opinion doesn't play a role in trial. I think it may have in this.
In this case, it may have. So he could have, again, getting on the stand, he could have clarified or validated some of what we saw or what we heard or the rumors. He could have validated these things and maybe shed some light as to, like you said again, now these boys, I go to Cedar Hill, this boy go to Duncanville, and if I heard about him at Cedar Hill, and again, these, like you said, these cities are, we from Cedar Hill. I'm from Cedar Hill. You're from Fort Worth, and you're from. So all of that stuff touches each other. So it's safe to say that if Attorney Andrew is a bully in Duncanville, and my Lancaster people know. So at that point, if he approaches me, no matter, like I think somebody said earlier, no matter how good or bad I can fight, this puts a different perspective of fear in my mind, because I know this boy done beat up 16 people in the last 3 months, or he's known for this, or he's known for. So does that as a defense attorney, do you use that? Because at the same time you said you want to paint your client, Karmelo Anthony, as a human, using these same tactics and theories, how does that paint Austin with the same paintbrushes?
That's a great question, man. It's a great question because you have people say, well, Austin Metcalf shouldn't be on trial here. He didn't do anything wrong. He was killed unjustified. You have these people who make all these arguments that that the trial should not be about the victim. But as a defense attorney, I beg to differ.
Okay.
Especially in a homicide case, because the rules of evidence says that the first aggressor and any communicated threats, that means anything that I know personally about you, any uncommunicated threats, anything that I may not know, but still it goes to your being aggressive can come in at trial against the deceased. So things that I know about him can come in as evidence. Things that I don't know about him, him being specific acts of him being violent, can come in at a homicide trial per the rules of evidence. So even though this case may not be about Austin Metcalf, Austin, Hunter, they would have been a big part of our defense in explaining to the jury why Karmelo was in fear of these boys.
How is it that we can learn as a community from this particular situation?
I think and I'm not being rash when I say this. I hope by now y'all know whose side I am on. But I don't think he should have spoke to the police.
Your client.
Well, Karmelo.
Never, right, when I say your client.
Yeah. I don't know. I do not.
Never should have spoke to the police.
No. But he didn't know that, though. So, you know what I'm saying? I'm just saying, you said, what can we learn? I think we can tell our children that when the stakes are high and when you think you're in serious trouble, I mean, it ain't every day, you stop by the police and they accusing you of something. You see what I'm saying? You probably want to remain silent and ask to have your phone call your parents, or just tell them you want to wait on an attorney. And no matter how hard that is, it got to be done. Because look, him not testifying without speaking to the police probably would have been a little better than him not testifying in the way it went, because they trying to figure out what he meant by it. You see what I'm saying? But if nothing was ever said, you see what I'm saying? You ain't got 21 people up there speculating about what he meant by it.
Man, you know what, y'all done taught me a lot. You know what, next time y'all try something, y'all gotta call me, let me be a special guest. No, I'm gonna mess the whole case up. I'm gonna mess that whole case up. Listen, I heard your opening statement. I am the judge. You said you the opener, he's the closer. I need to hear your closing argument. We gotta hear it.
You mean if the trial went the way I wanted it to go?
Either way.
I mean, you've heard from my client. At this point, you have no doubt that he believed that he was in fear of serious bodily injury or imminent death. You do understand that the law requires you to look through the lens of his eyes. I don't want to know what you would have did. When you about to check that box, because we all know what box you about to check. But before you check it, I want you to look through the lens of his eyes, because self-defense is subjective. Nobody can speak to what he thought before he defended himself except him. So if you are sure that this is self-defense, the verdict is not guilty. If you're not sure if this is self-defense, the verdict is not guilty, because that still means that the prosecutor has not proved their case beyond a reasonable doubt. If you think that, well, yeah, it was kind of self-defense, the verdict is not guilty. Ladies and gentlemen of the jury, you came here for jury duty. And no matter how small the fee is, please remember you're being paid to be here. And you're being paid to do the correct thing. And what you are required to do by law is check the not guilty box. Thank you.
Hi, nigga. Woo! You are now tuned in to the motherfucking greatest show on earth, man. Yeah. Hey.